Thank you so much for letting me be here today. I do appreciate the opportunity to come talk to you about Amendment 2 and the overall selection and election of appellate judges in Tennessee. It is, I would suggest to you, a very vital part of our economy, of our working system, and of our future in this state. I would also suggest to you that how we've been doing it in the past has provided us with a very steady and predictable appellate judiciary, and I think that you will find that ultimately Amendment 2 is our best option to continue and strengthen that as we move forward in the future. First of all, I would like to take a minute to talk about a little bit about the history of the Tennessee plan and how appellate judges have been selected for the most part since the early 1970s. In the early 70s, it has been referred to as the Modified Missouri Plan, the Tennessee Plan, any of those names. There has been some type of procedure for the selection of appellate judges that has been somewhat like we have today, and is akin to that we find in Amendment 2. The latest revision was adopted by the Legislature in 2009. And that revision established the Judicial Selection Commission that was comprised of 17 members from across the state. Those 17 members were appointed there were 8 members appointed by the Speaker of the Senate, 8 members appointed by the Speaker of the House, and there was one joint appointment made to constitute the 17 members. That was the Legislature's participation in the process of the selection of appellate judges. That commission would then meet anytime a vacancy came about and would recommend 3 names to the governor. And the governor would then select from those 3 names to make the appointment. Then after that, a retention vote would take place after assuming that the incumbent judge was able to get a favorable recommendation out of the Performance Evaluation Commission. There has been a Performance Evaluation Commission that's been a part of the system for a good period of time now that reviews the work of the judges. And in fact, if they were to give a negative recommendation, that judge could not stand for retention or election. The judge would have to stand for election if he or she chose to run, they would run in a contested partisan race. That has not occurred, and people say, well, the Performance Evaluation Commission has never rejected a judge. And that is true. There has never been a formal vote of rejection. But I would encourage you to think about and look back at history that there have been a number of judges that have not run for re-election in that setting. And quite frankly, the reason for that is that some of those folks realized that in all likelihood they would not get a positive recommendation from that body. So the system has worked, I would suggest to you, very well in that regard as well. As I said, in 2009, that system was put in place very similar to what it had been in the past. In 2013, the legislature allowed the Judicial Selection Commission, the Judicial Nominating Commission to expire, and therefore it went out of business. As a result of that, there had to be some changes. There is another provision under the law that allows the governor to appoint someone if the Judicial Nominating Commission cannot provide names to the governor within 60 days of a vacancy. So since the time that the Nominating Commission has been out of existence, that is what we've been operating under, is that provision. And so anytime that there is a vacancy, the governor has the authority to appoint. This governor has made a commitment to continue a merit selection process, and he has done that by way of executive order. And he has created an entity that's called the Governor's Commission for Judicial Appointments that functions very similarly to the way that the Nominating Commission worked. It's comprised of 17 members. It makes recommendations to the governor anytime there are vacancies of 3 members, and the governor fills from those 3. So that in essence is the procedure we have today. That procedure covers 29 different appellate positions. We have 5 Supreme Court positions. We have 12 positions on the Court of Appeals, which is the court that hears, the intermediate appellate court that hears all civil cases. And we have 12 judges on the Court of Criminal Appeals, which here is the intermediate court that hears all of the criminal cases across the state. There are 4 members from each grand division on the intermediate courts. So in other words, there are, in the Court of Appeals, there are 4 from the eastern section, 4 from the middle section, and 4 from the western section. The same is true of the Court of Criminal Appeals. So we have 29 judges that this process is impacting. Now, currently the trial court judgeships are also handled in this manner, although they then ultimately stand for a partisan contested election at the local level. What we're talking about today and what Amendment 2 addresses are the appellate court positions. Amendment 2 does not address trial court positions. So we're talking about the 29 appellate court positions across the state of Tennessee. What does Amendment 2 do? All right? What Amendment 2 proposes to do is, number 1, it gives the governor the authority to appoint, to fill a vacancy in an appellate judgeship. And the second thing it does is it gives the legislature the power of confirmation for the governor's appointments. And the third thing it does is allow the citizens of this state the right to vote for the appointees in a retention election. So, in essence, what Amendment 2 does is gives the voters 3 ways to influence the selection of appellate court judges in Tennessee. First of all, you as citizens are voting for the governor. That is a way you can exercise influence. Secondly, you're voting for your state senator and state rep. That's yet another way that you can influence the system. And finally, you have a direct vote on judges themselves in a retention election. Well, if this is really similar to what we've been doing, why do we need Amendment 2? The primary reason for Amendment 2 is to bring stability and bring conclusion and finality to the process. There has been legitimate debate about whether a retention election satisfies the current Constitution. I will say to you, there have been 3 special Supreme Courts, members of which were not current judges that were impacted by it, which have found that retention elections are constitutional under our state constitution. However, there continues to be some debate about that, and it's to bring some finality to that. The legislature came together along with the governor and passed this proposed constitutional amendment. And what this proposed constitutional amendment does is, in essence, patterns our procedure after the federal plan. But it is, in essence, a modified federal plan. It gives the gives the governor the right to appoint. It provides a check on the governor by having the legislature have an opportunity to reject or approve that position. And finally, it allows the people themselves to provide the final check on that to say. Some people say, well, if they're in a retention election, is that really an election? Obviously you've seen, many of you have seen what's occurred in this election the past few days with, there were an organized campaign seeking to replace 3 of the current justices. And I think you saw that it was clearly an election in that process. Secondly, I would point out to you, I think former Justice Penny White would certainly tell you it's an election, because in 1996, she was removed from office in a retention election. I oftentimes like to ask my friends that are political junkies and enjoy the trivia involved there when they try to say it's not an election. But I ask them the question, prior to the DeJarlais Lincoln Davis election a few years ago, when was the last time that an incumbent congressman lost a general election in the state of Tennessee? Anybody have an idea? Imagine Pat Nolan does. 1974. Yes, to 1974 when Harold Ford Sr. defeated Dan Kuykendall in Memphis. And so 1974 is the last. When's the last time a Supreme Court justice lost? 1996. I would suggest to you they are elections. But what happens here is the problem that you have, because the judiciary is in a unique situation, is also why we need Amendment 2. If we do not, quite frankly, ladies and gentlemen, if we do not have Amendment 2, we are in all likelihood headed toward contested partisan races for these appellate positions in Tennessee. You got a taste of that in this past election this last week. I'm sure you saw the advertisements, you received the mailers, but you have to understand, you only saw the tip of the iceberg of what can happen in a contested partisan race for judicial. There was approximately $1 million spent by both sides in this past election. When you look at states such as Alabama, Texas, Mississippi, Ohio, and any of those states that have direct elections, you will see that it is $6 million, $8 million, $10 million per position on the Supreme Court. Then you add in 24 other positions of an appellate courts, to where if indeed Amendment 2 fails, we face the distinct possibility of having 29 contested elections for appellate judges when the judges cannot articulate their positions. We are prohibited by our ethics laws to discuss issues. And I think we can all understand that, because no one wants a judge pre-committing to how they're going to rule in a case. And if they were to do that, they would have to recuse themselves from participation in the case. So you have a situation where you would be running a contested partisan race, would be unable to discuss issues, would be draining money out of the economy, and most importantly, every single state that has that now sees the great majority of that money coming from out-of-state interests. And we see those out-of-state interests come in and influence without any ability to truly know who is behind those advertisements. Now, I would suggest to you that over the years, we have had good Supreme Courts and good appellate courts. The process has worked. And I would suggest to you that without Amendment 2, we face the real possibility of that process coming apart at the seams. We will lose that predictability. We will lose that independence of the judiciary. And we will go back to a system that cannot produce what we need to attract business, what we need to secure the rights of our citizens in this state, both through the Tennessee Constitution and the federal Constitution, and we simply will have a much less fair and impartial system. Now, obviously, as we see here, the Farm Bureau as an organization has already endorsed Amendment 2. So why is it important that we be here today and we talk about that? It is incredibly important because, ladies and gentlemen, we need your help. This is not simply a situation where Amendment 2 is out there by itself and simply needs a majority of voters to vote for it. It is one of 4 amendments that will be proposed constitutional amendments that will be on the ballot in November. They will be just below the governor's race. But more importantly, not only is it one of 4, so there is a chance that people could overlook it. The most important point to remember is it does not take simply a majority vote up in favor of the constitutional amendment for it to pass. It takes 50% plus 1 of the votes cast in the governor's race for that same year. So as an example, let's use some round numbers. If 1 million votes are cast in the governor, let's say 1 million votes are cast in the governor's race, and the vote on Amendment 2 is yes of 495,000 votes, no 300,000 votes. Guess what? It fails. It's got to have 500,001 votes before it becomes a part of our Constitution. There's a natural inclination for voters, whether they think, I'm not quite sure about that, I'll just pass it, I don't want to read that garbage, that gobbledygook legal language that's on there, to simply pass it up. If you vote in the governor's race and fail to vote on Amendment 2, you have cast a no vote, effectively. That's the thing you have to remember, is you might as well have pulled a no lever for Amendment 2 if you vote in the governor's race and simply do pass over Amendment 2. That's why we need you. You are the leaders in your community. We need you not only to vote yourself, but we need you going out and talking to the people, talking to your friends, talking to your family, talking to your church fellows in your church, spreading the word. We have got to do that to make sure that we can have passage of this amendment in November.